Dear viewers, I am happy to welcome you all for another episode of What the Law Says. In today's episode, we are going to look at the rights and obligations of the landlords and the tenants and how you should rent out your premises and what are the things you'll have to watch out for. It is a dream for every individual to own a house. But once this dream is fulfilled, the excess income they make or the investment they look for is another piece of property which they think that they can rent it out and earn money and ensure they can pay the installments or make some other investments out of those rents. They think this is a most safest form of investment. It is indeed the safest form of investment, but to make it the safest, we need to take a lot of precautions. The landlords should ensure that they enter into a written agreement with the tenant, and they should know have some background information about the tenant. They should look at the identification papers they have, whatever papers, whether it will be an Aadhaar card, PAN card, whatever. They should ensure that they should inspect all these documents from the tenant. The tenancy, it is left to their will and wish how long the tenancy should go on. It can be as small as 11 months and it can go as long as 30 years, 35 years, it is left to their individual tailor-made solutions. But in that rental agreement, the landlord should ensure that the tenant follows and fulfills the obligation mentioned in the rental agreement or the lease agreement. A rental agreement or a lease agreement, both are same, just the name differs. A rental agreement should consist, when we speak on behalf of the landlord, that the tenant should not sublet the premises and it should be used for the purposes for which it has been rented out. We have this division of residential premises and commercial premises. So somebody cannot come and pick up a flat or an apartment or a house for residential purposes and use it for commercial activities. What happens is, this invites lot of statutory problems. The electricity board has different rates for commercial purposes and residential purposes. When the tenant rents out the premise for residential purposes and uses it for commercial purposes, what happens is they are violating the EB laws. So the electricity board will slap a notice, will issue levy penalties that you are availing current for a lower price and using it for some other commercial purposes. Who is the sufferer here is the landlord, because the connection is in the name of the landlord. So the most important thing, the landlord should insist that the premises should not be used for any other purpose than it is let out. And subletting. When you sublet, you are renting it out to a tenant. The tenant cannot have any right to bring in third persons to the property, because the agreement is very clear that only the tenant can remain there. So the landlords should be very careful about this. And apart from that, the other general conditions are there which speaks about not causing nuisance and maintaining the property in a proper way. It is incumbent when the tenancy agreement ends, unless it is extended, it is expected that the tenant vacates. But lot of times the tenant won't vacate for reasons well known to him. So the landlord has the option, the only option is of course approaching the court and filing a case to vacate the tenant. The tenant can be vacated for various reasons. The most important reasons are that the building which is occupied by the tenant is required for the owner's occupation, and if the tenant defaults on the rental amount continuously for 3 months or more, it's called willful default. The other reason being creating nuisance. If the tenant creates nuisance or causes damages to the property, then the landlord can ask the tenant to vacate on these grounds. And another important ground which is normally filed in the courts are for demolition and reconstruction. We are seeing a lot of old buildings. When those buildings, old buildings, the owner can seek to demolish that old building and reconstruct a new building, and on this ground also the landlord can ask the tenant to vacate the premises. The landlord should ensure, if it is above the threshold amount, that TDS is being paid by the tenant. The TDS is deducted at source when the rent is paid, and if it is for any commercial purposes, the GST or other taxes are paid by the tenant or deducted by the tenant and paid into the account of the landlord. These are the important statutory compliances the landlord should look into. And also be very firm that you have the documents in a proper manner. Maintain the documents in a proper manner. The rental agreement is a must. Repeat, the rental agreement is a must in a more complex legal world. You can easily establish your rights and obligations when there is a written document. So landlords, when you next rent out your property, ensure you enter into a rental agreement and define the rights and liabilities very clearly in those. Thank you viewers for watching this episode of What the Law Says. For more information and continuous update on the latest legal information, stay connected with us and subscribe to What the Law Says.